expertise and in-depth understanding of the law, he was given the Business Icon of the Year award by the ESQ Nigerian Legal Awards in 2018. He's currently the 30th president of the Nigerian Bar Association. After we listen to the president speak, we're going to also listen to Mr. Babatunde Erukera, the chief executive of the Federal Competition and Consumer Protection Commission, formerly known as the Consumer Protection Council. He was called to the bar in 1990. He was called to the Nigerian bar in 1990, and also before the Washington State Supreme Court in 1996. He's worked as an in-house counsel, general counsel, and advised senior government officials, as well as key government institutions on transactions, civil rights, commercial litigation, regulatory work, and practice management. He started overseeing the transition and operation of the Commission since January 30th, 2019, when the Federal Competition and Consumer Protection Act was enacted. He's responsible for the daily management and leadership of the Commission in fulfilling its mandate to promote market competition, protect consumers, and secure remedies when consumer rights are violated, and also with ensuring regulatory stability. Mr. Erukera has also played vital roles in sector-related consumer protection advancements, including advising the Nigerian Civil Aviation Authority with respect to its role in sector consumer protection. He led the initiative in developing current aviation consumer protection regulations, as well as the Passenger Bill of Rights. He has also provided capacity building and advisory services to government institutions and other clients with respect to competition and antitrust laws. Mr. Erukera is represented here by Mrs. Eme Ojugo, who is an Assistant Chief Legal Officer at the Federal Competition and Consumer Protection Commission. Our next speaker after Eme will be the head legal at First Bank of Nigeria Limited. A recipient of several academic and workplace awards, Raymond was called to the Nigerian bar in 1991 and holds a master's degree in law. He's an alumnus of the Lagos Business School and has attended executive programs at top-rated global institutions, including Harvard. He's a seasoned corporate legal practitioner who had a stint in private practice before joining the banks. He's worked at Nigerian International Bank Limited, now Citibank, Triumph Bank PLC, where he was company secretary and legal advisor and head public affairs before he joined First Bank in 2011. Raymond Ingbe-Okwere is the general counsel, First Bank of Nigeria Limited and its subsidiaries, a director of First Dependents Nigeria Limited and First Nominees Nigeria Limited. Over the course of his career, Raymond has had modest accomplishments in corporate finance, market development, and unique local and cross-border transactions. Raymond is a youth empowerment and leadership enthusiast. And after Raymond, we'll hear from the chairman of the Nigerian Bar Association Eket branch, Mrs. Gloria Etim. She holds an LLB from the prestigious Ahmadu Bello University, Zaria. After her call to the bar, after her call from the Nigerian Law School, she proceeded to the Center for Energy, Petroleum and Mineral Law and Policy, University of Dundee in United Kingdom, where she completed an LLM with distinction in energy law and policy. In 2006, she joined Mobile Producing Unlimited as in-house counsel and remained there till 2017, after which she joined Pearly Gates Associates in Eket, Akwa Ibom, as a senior counsel, where she has remained till date. She's also served as legal services consultant, Kwa Igbo Power Project Limited, Eket, since 2018 till date. She's an associate of the Chartered Institute of Arbitrators, UK. And after her, we'll listen to Mrs. Bumi Jasmine Omeke, who's on stage with me. She's the managing executive partner, JGC Partners. Bumi is a multifaceted lawyer, a lecturer, and certified HR practitioner who has applied her lawyering and management skills across various sectors, particularly in education, health, safety, and environment, employment relations, and general corporate practice. She's the managing and executive partner at JGC Partners, a Lekki-based commercial law firm. Bumi was called to the Nigerian bar in 2009, after which she proceeded to the University of Aberdeen, where she obtained a master's at law degree LLM in international commercial law with a commendation in 2013. Since then, she has worked with reputable law firms and educational institutions, which include being a one-time administrator at the Center for Law and Business, where she still lectures international undergraduate students of the University of London. Apart from her personal career goals, Bumi is a people-oriented person, and in that vein, she has taken up various social development projects, including being on the advisory and board of small and medium enterprises in the educational, telecommunication, and the health, safety, and environment HSE sector. Our last speaker is Mr. Reginald Aziza, a lawyer, researcher, and social activist. Reginald was admitted to the Nigerian Bar in November 2013. Presently, he is a counsel in the legal division of Chevron Nigeria Limited. Reginald has written extensively on various aspects of regulation of the legal profession, especially as it relates to the income-generating capacity of the legal profession and the remuneration of legal practitioners in employment. He's represented on the panel today by Adetola Onoyemi, who serves as Assistant Chief Negotiator for Nigeria and Head Trade, Remedies, and Investigating Authority at the Nigerian Office for Trade Negotiations. Adetola is also the winner of the Future Africa Awards 2019 prize in public service. In furtherance of the mandate of the Federal Executive Council and the Nigerian Economic Management Team, Adetola worked with a global law firm to develop a trade remedies infrastructure for protecting the Nigerian economy from injurious and unfair trading practices from foreign countries and companies. He's presently working on the full implementation of the Nigerian trade remedies infrastructure. Through the NOTN and select committees in the negotiating forum, he also participated in the pivotal work of negotiating the African Continental Free Trade Agreement after. So we're going to start with the comments of the Honorable Attorney General of the Federation, who is represented here by a Special Assistant to the President on Financial Crimes and Compliance, Mr. Abiodun Aikoma. Do we have Mr. Aikoma online now? So can we, Mr. Aikoma, will be talking to us for 10 minutes. I hope you can hear me.
I can. Good morning.
Good morning.
Madam, good morning.
Good morning. Thank you for joining us.
My pleasure. My pleasure. Good morning.
So you'll be speaking to us for 10 minutes. I would like to start with your views or with the Honorable AGF's views. He's chairman of the Legal Practitioners Remuneration Committee, established pursuant to Section 15 of the Legal Practitioners Act. What are his views on a comprehensive scale of fees for the legal services? And does he think that it would be useful? Please speak to us for the next 10 minutes. Thank you.
Okay. Good morning, Madam Moderator, and good morning, everyone. Greetings from the Honorable Attorney General and Minister of Justice, Mr. Abubakar Malami, who is absent. He sends his warm regards to the managing partner, Ajibade and Co., Dr. Ajibade, and sends his best. Now, going to the topic, the pros and cons and the challenges of establishing and enforcing a scale of charges for legal service. There is no doubt that the legal practitioner empowers the remuneration committee to set the scale of fees for legal practitioners and services in Nigeria. But there is, as observed by Ajibade in his own, the scale is observed often in brief, in practice. So the reality is that we have but what obtains in the market. It is difficult in this current scheme of things to have a comprehensive scale in Nigeria. And because the reason for this is there are so many factors that are involved in charging professional fees. If I may, the novelty of the issue, the time and labor involved, the amount involved in the case, if it is a monetary claim-based case, the location of the trial, if it involves involves traveling, involved. And also in Nigeria, we operate a capital system, a free market economy. It is difficult to bring out scale of fees, and regulate holistically at the expense of so many other issues that require reform in the practice and in the Nigerian economy. For instance, there have been so many clamor from different quarters as to the influx of foreign firms practicing in Nigeria. There are financial transactions in Nigeria that are Nigerian. It's some of the aspect of transaction maybe is receiving finance from. I mean, in this regard, you find foreign firms, tier one firms in the UK and elsewhere participating to the detriment of Nigerian firms. So there are so many issues which call for reform of the practice of law in Nigeria. So the position of the Attorney General is that we cannot single-handedly take out fees, as it were, but there is a process ongoing to look into everything holistically as stakeholders, as practitioners, as everybody involved. I mean, it is cheering to note that Dr. Ajibade has invited even the clients. When you want to talk about bill of fees and regulating same in an economy like what we have in Nigeria, where the minimum wage is 30,000 and states are struggling to pay, where the government in some quarters is having difficulty in meeting obligations on payments to staff. There have been agitation between labor and the government on minimum wage, and it is still ongoing. So the essence of the law is not to create a law for the fun of it. The law must be realistic, it must be implementable. So if we want to focus on establishing a scale of fees in Nigeria and seek to enforce it, to what extent can this be achieved in the current scheme of things? So the law profession is a purely regulated business profession, and lawyers are bound by so many lawyers. So at the moment, what the Office of the Attorney and the Attorney Chairman of the Remuneration Committee is concerned about is to ensure that lawyers keep to the fine tradition of legal practice, that lawyers behave professionally, that lawyers keep to the ethics of the profession, that lawyers do not behave in a way that is detrimental to the interests of their class to move along gently her. But to say, like in the era of the common law, this is a comprehensive scale for lawyers in Nigeria. If you do this transaction, you charge X. If you do Y transaction, you charge Y. It's very difficult to enforce under the scheme of things. And the law is not meant to just be enacted or be when we know that the reality on ground does not support it, but additional professionalism and respect for the practice in Nigeria at the moment. But like I said earlier, efforts are ongoing, the practice of law in Nigeria. They are lost pride of place in saying.
Okay, I think we've lost him. So we're going to move on to the next speaker, Mr. Kokomo, Mr. Aikomo. I hope you still stay on with us because we have a lot of questions. I've listened to your presentation and heard the views of the Honorable AGF, and I see that there are questions coming in already. So I hope you will stay on, and when the line is clearer, we can come back to you for some more questions. But I'll move on now to the President of the Nigerian Bar Association, Mr. Olumide Akpata, for his comments on this topic. Mr. President, can you hear me?
Yeah, Shola, I can hear you. Can you hear me?
Yes, I can hear you.
Mr. Ikomo is back on.
Okay, but I'm going to stick with you. I'll go back to Mr. Ikomo later. Mr. President. Hello?
I can hear you, Shola.
Yes. As a statutory member of the Legal Practitioners Remuneration Committee, which has not recorded any activity for quite a while, has the NBA formed a view as to whether or not the establishment of a scale of charges is necessary for services offered by legal practitioners in Nigeria? What is that view? Please share with us.
Okay, thank you, Shola. Thank you very much. The NBA has a view, has a very strong view on this issue. And yeah, it's quite unfortunate that that committee has been almost comatose for a while now. I'm hoping that we can get it to do more. Shola, you will permit me, the invitation I received was one to be a guest speaker at this event. So I actually have a prepared speech. So I don't know if you're going to have time to listen to me because we have our views on this matter. And I think it's such an important matter that we will need to speak to clearly and without equivocation, and to ensure that we are not misquoted on the issues. I do have a prepared speech as guest speaker. Yeah, thank you very much. So let me share my screen because I'm not so sure whether or not you can hear me or everybody can hear me. So I'm going to share my screen now. Okay, well, it looks like I need to be enabled. So I hope the host will let me share my screen as I go because there's quite a lot to say. So first and foremost, thank you, Shola, and thank you to the organizers, particularly thanks to my dear brother, Dr. Tunde Ajibade, Senior Advocate of Nigeria, for this invitation. I'm happy that the SPA Ajibade ABL continues into its 13th edition, and I'm happy to note that I am, at least of the 13, I must have attended at least 10. So I'm happy that we're keeping the flag flying, and I'm glad to be part of the success story of the ABL. And I recognize, of course, the presence of the Attorney General of the Federation, represented by my dear brother, Mr. Ikomo. And I will stand on existing protocol and just say, good morning all. It's my pleasure to speak to you today on this very important and frankly existential issue. The pros, the cons, and challenges of establishing and enforcing a scale of charges for legal services in Nigeria. Let me start by saying that generally, there's no law or rule in Nigeria that tells lawyers how much they must charge their clients for the provision of any legal service. The basic rule and all that is required is that the fee charged must be fair and reasonable. This is the practice in many jurisdictions, including the United Kingdom, where the Law Society of England and Wales generally requires a fee that is fair and reasonable. Having said that, I must quickly state that we have a defined scale of charges for certain non-contentious legal services in Nigeria. That scale is prescribed by the Legal Practitioners Remuneration and Legal Documentation Order. Although the provisions of the order are written in mandatory terms, Section 5 gives lawyers the rights to elect whether to charge in accordance with its prescribed scale or to charge an amount that appears fair and reasonable. So in essence, the basic mandatory rule emanating from the remuneration order is that a lawyer's fee must be fair and reasonable. Fairness and reasonableness in this regard are determined by reference to, amongst other things, the complexity of the matter, the time and energy of the matter, the lawyer, the quantity of use, the location of the lawyer, the monetary value of the transaction, and the idiosyncratic value of the transactions for the client. The order is based on sound legal and commercial reasoning. However, its value has been lost because of our collective failure to abide by it and to consistently update it to reflect changing economic realities. The discretion given to lawyers in relation to their fees is not an absolute one. Fairness and reasonableness operate to prevent gross underpricing and excessive overpricing of legal services. There are very few instances of excessive overpricing because clients have the ability and incentive to police and challenge their lawyers' bills. However, gross underpricing has become pervasive in our legal service market for several reasons, including the willingness of many lawyers to accept paltry amounts from a client just to make ends meet and to retain the client's business, and also the cost of and difficulty in tracking down and penalizing cases of excessively low legal fees. Lastly, even if we were able to enforce and forestall the cases of gross underpricing, there is the risk that such enforcement will create shadow markets for legal services. I will come back to this point later. The core problem undergirding the topic today is this challenge of gross underpricing and the negative effect it has on the dignity of the profession and the ability of lawyers to earn a living wage from the services that they provide. Clients have no incentive to enforce fairness and reasonableness in relation to underpricing. After all, we are all too familiar with the usual threats from clients to take their business elsewhere if a lawyer does not accept an unreasonably low fee. This is something we must do ourselves, and that is why this conversation is timely and necessary. In establishing a scale of charges, there are generally four options. Firstly, we can contemplate fee caps with the discretion to charge lower. Secondly, we can have uniform or fixed fees with no discretion to charge lower or higher. Thirdly, we can have fee floors as in FLOORS, with the discretion to charge higher. And lastly, we can have ad valorem fees, a scale which we may use all of this option and may or may not subject them to fairness or reasonableness. Imposing market-wide fee caps on the charges for legal services could become an unnecessary incursion into the freedom of contract, which all lawyers should enjoy with their clients. It could also be an affront on the principle of laissez-faire, which generally undergirds the market for legal services and will be met with instant and significant pushback from most lawyers. These concerns will remain even if we have concerns multiple fee caps, determined by reference to and other variables. More importantly, fee caps do not account for the complexity of the instruction, the location and experience level of the lawyer, and they will also not solve the problem of underpricing. If anything, they may exacerbate it. However, one advantage of fee caps is that they serve as an important consumer protection function, particularly in relation to contingency fee arrangements for contentious matters. To prevent this and to protect clients, there should always be a cap on how much a lawyer can recover as, for example, success fee in certain contentious matters. For the same reason, instating and enforcing uniform fixed or ad valorem charges for legal services may also be counterproductive. In particular, a uniform or ad valorem scale of charges would be. Now I'm going into ad valorem scale. I haven't left fee caps. It will be difficult to design. The design difficulty stems from the fact that legal service market, client types, legal work, and the complexity thereof in Lagos, for example, is somewhat different from what we may obtain in Abakaliki. Even within Lagos State, such differences may be seen across the different areas of the state. A uniform scale of charges for these structurally different markets and for lawyers with different levels of experience would not only be unfair and irresponsible, but would also be regressive and may trigger a race to the bottom. I will give you an example. Let us impose a uniform fixed or ad valorem fee for 10% of the purchase price of real property within Nigeria. So 2 real properties are to be acquired by a single client, one in Ikorodu, 20 million. And assume that the records in the Borno Land Registry are incomplete or inaccurate on account of years of insurgency. This is just an assumption and not necessarily fact. Clearly, traveling to Borno introduces an added layer of complexity and risk that the 10% fixed fee would not account for. The lawyer would earn more from the Lagos transaction, which was fairly straightforward, and earn less from the complex and risky Borno transaction if we have this fixed fee or ad valorem structure in place. Circumstances like this form part of the reason, part of the jurisprudence behind the exception and the power of election given to lawyers under Section 2 and 5 of the Remuneration Act to charge varying fees and to apply fairness and reasonableness. The failure to account for experience level is also a significant challenge when with fee caps and uniform fees and ad valorem fee arrangements. For example, let us say we instate a scale saying that lawyers of 10 years post-call must charge X naira for providing a particular legal service. If the legal service in question is a contract for the installation of a solar panel and the sharing of carbon credits, let me just bring one complex transaction as an example. Would it be fair for someone who has spent 15 years practicing in the legal department of an insurance company, or whose entire 15 years of practice has mostly featured criminal litigation, to claim that they can charge X naira for the provision of that service? Do they really have 10 years experience in the provision of that kind of service? Should they be entitled to earn the same as someone who has 10 years experience negotiating and drafting solar PV installations and carbon credits sharing contracts? This raises a significant ethical question on competence, and we have generally not been able to properly enforce Rule 16 of the RPC, which imposes an ethical duty on lawyers not to handle any legal matter which they know or ought to know that they are not competent to handle. Interestingly, the scale of charges prescribed in the remuneration order employs a mix of fixed and ad valorem fees. These fees are generally determined by reference to the value of the transaction without more. They do not factor in other relevant indices like complexity, location, and experience level. This is perhaps why lawyers rarely assess their fees on the basis of that scale of charges, but prefer instead to charge fair and reasonable fees, which factor in all relevant indices. Ad valorem rates may be perfect as the sole basis for assessing regulatory charges, but they should not, in our view, be used as the sole basis for determining professional fees. What appears to be practically feasible and enforceable, therefore, if carefully designed, is a scale of charges that imposes fee floors, FLOORS. That is, minimum fees that may be charged for each type of legal service in order to maintain the dignity of the profession and provide reasonable income for lawyers. If properly designed, I repeat, and enforced, this will go a long way in eliminating underpricing, and lawyers would be free to charge higher than the minimum to account for complexity, location, experience level, additional risks, and other relevant indices. However, ladies and gentlemen, setting and enforcing such a fee floor comes perilously close to price fixing. I'm quite sure, actually pretty certain that our friend and brother, the Director General of the FCCPC, Mr. Tunde Rukara, will tell us that our clients and other consumers of legal services are customers or consumers within the scope of price fixing prohibitions in the FCCPC Act. Without preempting what the DG will say, I will talk about the pros and cons and challenges of establishing and enforcing a fee scale that prescribes the minimum charges for legal services in Nigeria. The basic advantage with a fee scale that prescribes reasonable minimum charges is that it allows for an increase in the earning of lawyers, and in doing so, protects the dignity of the profession. I'm sure many of you watched the skit on our colleague Funke Giwa in Ibadan, and I'm sure it must have tugged at your heartstrings just to see how difficult it is for lawyers to make earnings for lawyers in today's world. This fee increase comes with a risk, and in that risk lies the disadvantage in this minimum fee floors. It may lead to the creation of a shadow market. Such a market currently exists. Estate agents and other persons now perform conveyancing services. Clients are happy to work with them since the fees paid to them may be lower than the fees charged or chargeable by lawyers. We have seen banks and other professional services firms leveraging on their economies of scale and scope to provide services which should ordinarily be the exclusive preserve of lawyers. These shadow markets for legal services reduce the pool of work available to lawyers. Imposing minimum charges for legal services without first defining and defending our turf will simply force clients to send their work to these other persons and companies who may be willing to do the work for a fraction of the first necessary step, therefore, would be to define and expand the scope of services that are the exclusive preserve of lawyers, defend it, and impose consequences for non-compliance, such as the nullity or non-registrability of the documents so prepared, or the voidability of the transactions concerned. After we deal with this challenge, we may then impose.
Mr. President.
Shola?
Yes, can you hear me?
I can hear you. Can you hear me?
Yes. I think I'm going to pause you there and come back to you because you've exhausted the 10 minutes that you were supposed to speak for. But I understand that you still have a lot more to say, and we're going to come back to you. But I want to walk around the room and take our next speaker.
Thank you, Shola.
Okay, so I'll come back to you. Thank you, Mr. President. Thank you for that well thought out paper. I'm going to go on to Eme Ojugo, who is an Assistant Chief Legal Officer at the Federal Competition and Consumer Protection Commission. She's representing Dr. Babatunde Irukera. Eme, are you there?
Yes, I'm here. Good morning,
okay.
Shola. Good morning.
Now, question for you. There's a possibility that some might see an attempt to fix a scale of charges for any service as anti-competitive price fixing. Do you think that there's any justification for such reasoning?
Okay, thank you, Shola. Before I start, I would just like to send the EVC's warm regards. Unfortunately, he's unavoidably on some other official assignment, but I'll do my best to stand in his stead. So really, a scale of fees is a way of charging for legal work based on a standard scale rather than based on perception of the amount of work done. And it is not only for the financial interest of legal practitioners, but also for clients and interest groups. Under the rules of professional conduct, a lawyer is required to charge for his services that are reasonable and commensurate with the service rendered. And so basically a scale of charges will seek to determine what is appropriate and commensurate per service. The rationale for establishing a scale of charges are numerous, and I will mention a few. It ensures transparency. There are no hidden charges. It provides for uniformity, discipline, and prevents arbitrary pricing. And so really, when you look at it that way, it's pro-competitive. However, there are certain unintended consequences, such as the lack of flexibility and inability of legal practitioners to exercise discretion. It also could lead to a reduction in innovation, reduced output or input, and continuing legal education, and in some cases constitute as a barrier entry for new entrants. And most importantly, it could promote exclusivity for a class of professionals within the profession. So I will go on to the question now. The question is, can an attempt to fix the scale of charges for any service be regarded as anti-competitive? And looking at the Ghana scale of charges, it's advisory in nature. So does it compromise competition? In a manner of speaking, yes. However, the question of competition is hardly rigid per se. It is always a purpose and an effect test. Whether there is a coordinated conduct and whether the nature of the structure of the scale of fees and its operation act in a manner that substantially limits or prevents competition. And that is usually what the commission will look at. So I'll look at if it seeks to penalize legal practitioners for offering quality and appropriate services by charging a rate that is less than what is appropriate or commensurate with services rendered, then it is anti-competitive. But on the flip side, if a lawyer decides to offer a key service at a fee that is manifestly and unreasonably low to undercut the market custom of a client, then that act in itself is anti-competitive. The purpose and intention is the key issue. What is the purport of the scale of charges? Because under the FCCPA, generally, it is required that each company, each business will determine its own pricing methodologies and business strategies without collusion with its competitors or market participants. Any agreement between industry participants that seeks to regulate or manipulate prices and restrict competition in any way is an offense under the Federal Competition and Consumer Protection Act. The damage caused by such collusion cannot be overemphasized. The important point is not how the agreement was made, how the understanding was reached, or even how effective it is, but that businesses who are supposed to be are working out their prices and not individually. As such, an agreement could be formal, it could be a wink, it could be a nod, it could be made over a drink at an association meeting, or even an unspoken norm. It could be an unspoken norm. It is just understood by parties that this is how we roll. And so, but the thing is that under the FCCPA, businesses are allowed to coordinate in a way that is pro-competitive. And the law mandates the Commission to make regulations that cover such accepted situations. Businesses can get clearance in form of exemptions from the Commission, approving coordination in the interest of public. And listening to the president of the NBA, you could see that a scale of charges could actually be beneficial to consumers and lawyers alike. So the Commission will look at the public interest, will look at the efficiency and advancement or any pro-competitive rationale of that scale. And while seeking to ensure that consumers enjoy a fair share of the resulting benefit. So the Commission is going to be looking at the balance in that scale of charges. And really, there could also be an argument for it being a tool of promoting competition when it does not operate as an entry barrier to new entrants. Furthermore, there's nothing in the Act that prohibits activities of professional associations designed to develop and enforce standards of professional qualification. And with respect to these professional services, the Commission is required to issue guidelines from time to time for the conduct of this professional association. So I would like to reiterate that question. The issue of competition when it comes to fixing a scale of charges is never rigid. It is looked on a case-to-case basis. Like I said, the operation, the nature, the structure of the scale of charges will determine its effect in the market. And the Commission will generally be looking at the purpose and the effect, what is its intention, and what is going to be the effect on the market. So when the Commission seeks that balance and finds that balance, then there's really no answer. It's not yes or no. It could be, it could not be. So thank you very much.
Thank you very much, Eme. Do we have our poll questions up, our participants? Can we take one of the poll questions for the next speaker, the banker? Can we have the poll question on? Can you make it bold so I can see the results? Should we just go on? Okay, so we have the second poll. Do you think the establishment of a comprehensive scale of charges for legal services in Nigeria will be anti-competitive and thus bad for legal services? And 43% of our respondents voted yes. 66% voted no. What about the first poll? Do we have the results for the first poll? On the question. We'll take it subsequently? Okay, great. So we'll go on to our next speaker, Mr. Ngbekere, who is the head legal at First Bank of Nigeria Limited. Mr. Ngbekere, are you online? Hello?
Yes, I am, Shola. Yes, I'm here, Shola.
Yes, thank you for joining us.
Can you hear me?
Yes, I can hear you. Thank you for joining us.
Thank you.
So you are a banker and a client. And the question is, the legal practitioner's remuneration for legal documentation and other land matters order establishes a scale of charges for legal practitioners engaged in the preparation of mortgages, amongst other legal documentation. Now, anecdotal evidence has it that banks are the worst culprits in refusing to pay legal fees prescribed by the order. Is this correct? And what do you suggest the legal profession can do to remedy this?
Thank you very much, Shola. Thank you for having me. Let me start by thanking you and thanking SP Ajibade and Co, who are doing the 13th annual business luncheon of theirs. Clearly, they're here to stay because if they are not serious about this, there are many micro and macro reasons and excuses to walk away tactically from this year, but they've stood the test of times and we're here today. To your question, I'd like to say that I take it that banks means clients for this purpose. I was going to use the word consumers, but since FCCPC is here, I don't want to sound as if I'm working with them. So let me use the word clients as those who are allegedly the biggest culprits in refusing to pay
legal fees.
The legal fees. Yes. I do not think for now it is about the clients. In my estimation, I think lawyers are not charging in accordance to that scale, largely. I'm not sure any law firms in Nigeria have ever issued invoices in accordance with that scale. Perhaps when the order was made initially, a few lawyers may have tried, may have experienced clients' resistance, which is normal. And maybe they gave up too quickly. As you know, no business and nobody jumps at paying out more where they can pay less. You know, don't forget also, like the president of NBA mentioned, only a lawyer who breaches this order is sanctionable. The client does no wrong. You know, and the breach of this order doesn't, like the president said, doesn't invalidate the transaction. It doesn't make it voidable. No penalty, nothing. It just goes through. As he also mentioned, you know, this scale that we have today is very limited to some very few areas. Between when it was set, done in 1991 and today, there are so many new things happening. And at risk of going back to the polls we conducted earlier, I think the awareness of this order amongst lawyers is very, very low. Among those who know about it, how many understand it the way it's written? Among those who understand it, how many believe in it? You know, and among those who believe in it, how many lawyers pay this scale when they find themselves as clients in transactions?
Hello?
How many lawyers who sit in companies where they have investments?
Hello?
Yes.
Your video is off. Can you turn it on so that we can see you and follow you?
I'm so sorry. Can you see me?
Yes, we can. Thank
I'm
you.
so sorry. I'm so sorry. Yeah, so how many people who speak to this as lawyers, when they sit in board meetings and in companies that have investments, how many are happy to pay the scale? And beyond that, do we own this order? Do we believe in it? Because when you own something, you preach it like a gospel. So I think that if we want to go by scale of fees, we have to start afresh. The president has given indications as to how rigorous the thinking that will go with a new and revitalized order will be. It's not just writing lines, it has to be something that's thought about so well. It must come with a new enabling law, which, for example, makes it very business friendly, makes it recognize that the tougher jobs have to be paid for in a better way. Routines can never earn the same fee as the complex. The same way, it must give a window, maybe a kind of band where you have the upper and lower limits. Because even in practice, some law firms run higher expense lines than others. So they may put themselves at the upper edge of any band, while the lower law firms run with the lower band in each scale. And you know, for me, ultimately, if a new law has to come out, it also has to be one that meets and works carefully, not to find itself caught up with the FCCPC. Because that act could be to our advantage or to our disadvantage the way we word it. I also think that lawyers and all of us here in the profession need to introspect a bit more about why do we always find ourselves taking the shorter end of the stick in transactions? Why are we always attracted to the little things. Why are we waiting and watching the market move against us, where other professions are eating our lunch? For example, compliance officers are interfering in legal practice, consultants are doing same, risk managers are doing same, governance professions are doing same, and most recently, you hear things like conduct professionals. These are all touching on what law and lawyers do. And I think that's what the president was going to mention around the need to defend ourselves. And I think people pay for value. Lawyers must give value and they can therefore charge for value. Also, this scale that we have today, the scale of that we have today, would you think they are unreasonable? Or is it that we don't, why do clients feel that we don't earn it? Is it the way we present ourselves to our clients, the way we package ourselves, that make them doubt if indeed we are due the kind of scale we're asking for? So in conclusion, in response to your question, I think this is part of self-regulation, which has to be very intense and very, very deliberate in terms that being a professional thing we're doing for ourselves, it is how much we commit ourselves to driving it that makes it work. It cannot work necessarily because we have administrative procedures or we have a law or we have a provision. It's about deepening and realizing that our lives depend on what we make of our profession. And professionally, all of us are agreeing to support it. Don't forget that no defaulting lawyer will self-report. And when a lawyer next door sees a colleague who is breaching and reports him, you will hear that it's about witch hunting. And you ask yourself, even when you witch hunt, if I must use that phrase, how do you produce evidence that truly the lawyer charged less than he should have charged? Where there's no regulation today that shows, that makes mandates lawyers to file returns in any place to show their business transactions. Nobody has any access to lawyers' books to audit it or to see what they do. So without that regime of compliance, which leads to enforcement and which leads to sanctions, how are you going to do it? So it's a very deliberate thing you have to do to save the profession. Thank you very much.
Thank you, Mr. Raymond Ngbekere. We'll come back to you on the Q&A, but let's take our next poll. Do we have the poll on the screen? Can't see. So we'd like everyone online, all our participants to vote on this poll now so that we can read out the results immediately. What has been the cause of the failure of compliance with the legal practitioner's remuneration for legal documentation and other land matters order of 1991? 1, a failure of the disciplinary mechanisms in the profession, undercutting arising from the intensity of competition, a lack of cooperation from clients, or insufficient awareness of the existence of the scale. What has been the cause of the failure of compliance with the legal practitioner's remuneration for legal documentation and other land matters order of 1991? Do we have the results? Okay. I'm going to come to you, Mrs. Etim, but I want to take our results first so that you work it into your comments when you make them. So we'll just come up with the results shortly and then we'll come to you. Do we have the results? So I think my connection is bad. I'm not seeing the results. So I'm just going to come to you. Okay, yes, I see it now. The failure of the disciplinary mechanisms in the profession, 24% voted. Undercutting arising from the intensity of competition, 43%. 10% have voted for lack of cooperation from clients, and 24% have voted for insufficient awareness of the existence of the scale. So undercutting arising from the intensity of competition, 43%. Mrs. Etim.
Yes, please. Good
Yes.
afternoon.
Are you here?
Yeah, good afternoon.
Good afternoon. Thank you for joining us.
Thank
Did
you.
you see the results of our poll?
Yes, I saw it. I saw the
Great.
result.
So we're going to kick off from there. Anecdotal evidence supports the assertion that the only scale of charges of general application in the legal profession in Nigeria at present, the legal practitioner's remuneration for legal documentation and other land matters order is of little use because it is rarely complied with. This is despite the fact that Section 7 of the order makes charging outside of the prescribed scale a professional misconduct punishable by the Legal Practitioners Disciplinary Committee. What is the reason why this provision has been so ineffective and so poorly enforced? And you saw that our poll, 43% have voted for undercutting arising from the intensity of competition. What are your thoughts?
Let me thank you for having me here. Thank you very much, Ola. Thank you to all the panelists, my president, Olumide Apata. Thank you for being here. I recognize the Attorney General. And let me send special greetings to all the panelists. And from the Nigerian Bar Association, a very big thank you to Dr. Ajibade, SAN, the promoter of this dialogue. As a matter of fact, the issue of scale of charges for lawyers has been on the front burner for quite a while. Specifically, I'm going to be dealing with section the legal practitioners' remuneration for legal documentation and other land matters order of 1991. Section 1 of that order makes very clear provisions for the regulation of legal practitioners' charges for businesses connected with the sale, lease, mortgage, and other matters of legal documentation, as long as they are not connected with an action in courts. It goes further to specify the charges in the different parts of the schedule to the order. Now, in my opinion, and I must say that as I prepared for this, I spoke to a cross-section of legal practitioners, and the response was the same. The regulation of professional fees, in my opinion, in respect of matters stated in the 1991 order, was specifically to ensure that lawyers are not undervalued and that their services are not underpriced. But in reality, this has not been achieved at the moment. Indeed, anecdotal evidence shows clearly that the scale of fees are complied more in contravention. I think the representative of the Attorney General of the Federation also mentioned this, in the sense that most lawyers, if not all, and this cuts across junior lawyers and senior lawyers, do not comply with the scale of charges in respect of matters in the order. Lawyers clearly charge outside the prescribed scale. And to this extent, in my opinion, the law is of very little, if any, use at all. When, as I said, I spoke with a cross-section of lawyers, and as the poll has shown, the results of the poll has shown. The responses I got were in this manner. One, the fees prescribed in the scale are not realistic at all. Why is it not realistic? It does not reflect, they do not reflect the economic realities of our time. The fees do not take into account current inflationary trends. And of course, lawyers patronize the same services, participate in the same markets as all citizens, with no price differentials. They also have responsibilities to meet up with income derivable from their practice. Another problem the lawyers expressed was that the fees, and that is true, is abysmally low. So low that the law itself has become obsolete. We would see that the order was made in 1991. This is 2020, 30 years on. And we'll come to that soon. 30 years on. In fact, the 1971 order that repealed that was repealed to make room for the 1991 order existed for 20 years too, 71 to 91. And 91 to date, 30 years on, we're still operating that same law. It does not meet with realities at all. Another problem, especially this came from the younger lawyers, is that even the senior lawyers do not comply with this scale of charges. And so they do not have any obligation to comply as well. Unfortunately, it is the lawyers themselves that are contravening the very laws that were meant to regulate us. I looked at the Ghanaian scale of charges, which was introduced in 2015. And I saw the scale of charges there. Apart from the fact that the Ghana scale is a bit more recent, 2015, the rates, as a matter of fact, as I see it, are more realistic, they are negotiable, and they are easy to calculate, as opposed to the Nigerian scale of charge, which, like I said, is obsolete. Again, the Nigerian scale of charges is non-negotiable, clearly stated in Section 7, subsection 2 of the 1991 order. It is not negotiable, it is compulsory, and yet it is not enforceable. The question is, why do we still have it sitting on our statute books? As I looked at the Ghanaian law, and like I said earlier, even the introduction thereof clearly states that the basis, it is a guideline, so to speak, that the basis of the guideline for professional charges for legal practitioners shall be negotiation and agreement between the lawyer and his clients before commencement of legal services. So there is room for negotiation. That is why the Ghanaian, with regards to Section J of the Ghanaian legal scale for legal charges, it speaks in percentages so that lawyers are able to negotiate within that range of percentage. So it allows for competition, in my view. That's why I know said it stifles competition, but I do not agree, because there's a range within which you can negotiate your fees. Now, the part similar to that, like I said, is Section J, which makes provision for example for charges with respect to conveyances. Now, in the Ghanaian law, apart from the initial consultation fee, which is clearly stated there, ranging from 500 Ghanaian cedis, if you go by the current conversion rate of 64 naira 82 kobo to 1 Ghanaian cedi, then you have a younger lawyer of 1 to 5 years under the Ghanaian scale of charges, having 33,000 for a start for his consultation. lawyers from 6 to 9 years having 750 Ghanaian cedis, and senior lawyers 1,000 Ghanaian cedis, which translates to about 65,000 naira as consultation fee. Now, depending, as I said, on seniority at the bar. The fees for conveyance under the Ghanaian law is specified in percentages. And I took, for example, where the first therein said that for conveyances, the fees of a conveyance is based on the value of the property. I know there's one of the panelists also spoke to this. In fact, our president spoke on this, that in Nigeria, the scale of charges under the 1991 order does not take cognizance of things like location of the properties and so on. The Ghanaian law also just goes ahead to say it depends on the value of the property. And I would think the value of the property would depend also on the location of the property, because you cannot price, for example, where I live in Ekiti, you cannot price a property in Esreke the same way you will price a property in Ekiti urban. So to that extent, I believe that the scale takes care of that in itself. Now, I saw in the Ghanaian order scale of charges that, for example, a property with a value of 20,000 Ghanaian cedis, all right, that would translate to roughly 1.3 million in Naira, would earn a lawyer 15% at the most, the highest being you can negotiate to maximum of 15% for your fee. Now, if a lawyer competitively is able to agree and to negotiate and agree with the client for 15%, the lawyer gets 3,000 Ghanaian cedi, and that will translate to 194,000, call it plus, that's about 195,000 naira. Whereas in Nigeria, if we go to charge according to the legal practitioners' remuneration for documentation and other land matters order 1991, for a property of about 1.3 million naira in value, the lawyer will struggle through a rigorous and very cumbersome calculation in the scale of fees. I have it here. Let me take, for example.
Thank you, Mr. Exim. I think I'm going to stop you here. Hello, Ma. Can you hear me?
Please. Yes, please. I can hear you.
I think I'm going to stop you here, but we'll come back to you on the Q&A. You've raised some very, very interesting, topics, comments that we need to trash. But I'm going to move on to the next speaker. I'll come back to you, Ma. Thank you very much for your contribution. So we're going to take the next poll before we listen to the next speaker. Can we have the poll online?
Congratulations, Madam.
And the question of the poll is, who is more likely to benefit from the establishment of a comprehensive scale of fees for legal services in Nigeria? The consumers of legal services or the legal practitioners? I believe you're going to speak to us next. But I think we should wait a bit and let everyone take part in the poll and then read out the results so that you can work whatever results that we get into your comments. Can we have everyone vote on this next poll? Who is more likely to benefit from the establishment of a comprehensive scale of fees for legal services in Nigeria? The consumers of legal services or the legal practitioners? Do we have the results? Okay, so the results are there on the screen. We have 74% have voted for the legal practitioners who are more likely to benefit, and 26% say is the consumers of legal services. Bumi, does this surprise you? You You work in the small and medium scale. Yes, your primary interest is in employment creation, and this makes the micro, small, and medium enterprises category of particular relevance to you. To what extent, having seen our results, to what extent do you think the establishment of a scale of fees for legal charges could be beneficial to legal practitioners and to consumers of legal services in the MSc space? Do you even agree that some legal practitioners qualify as MSMEs themselves?
Thank you very much, Shola, for having me. I think the good thing, the advantage of being one of the last speakers is the ability to synergize what everyone has said, what every speaker has said, and even add more to it, make it better. Thank you. All protocols observed. Good afternoon to all the viewers. The Attorney General of the Federation of Nigeria, of the Federal Republic of Nigeria, Mr. Olumide Akpata, the President of the Nigerian Bar Association, my fellow senior learned colleague. I would like to take your question from the second part because it will help me to address the first part. And that is if lawyers are MSMEs. I would say categorically yes. For the purpose of sounding politically correct, I would say maybe 99.9% are MSMEs. Yes, of law firms are MSMEs actually. By the definition of MSMEs from an employment angle, it says MSMEs are enterprises with less than 250 employees of labor. So in that sense, you will all agree with me that most law firms have, yes, they have less than 250 employees, at least in Nigeria, that I know. And I would also like us to note the importance of MSMEs in the Nigerian economy. I'll say about 50% of job creation come from that sector. And 90% out of that 50% comes from the manufacturing sector. So that's to show how very important the MSMEs are to the Nigerian economy. Having said that, I will move to the first question, and I would like to address it under 3 sub-headings. First of all, I will talk about the challenges from an experiential point of view as a lawyer within that space, and as a lawyer who is relating with business owners within that space as well, that's within the MSME space. I would also talk about, I also assess the existing legislation. Of course, they said the previous speaker has spoken on the lack of enforcement and all that, but it's good to look at the content, you know, what this legislation have. And I mean, it might really be the reason why it has not been enforceable. And then I would also make my own recommendation. Talking about the challenges, experientially, I've been approached by business owners from the MSME sector to carry out some legal services in our law firm and all that. And then they come back to me halfway down the line, they come back to me to say, you know what, I think your pricing, I mean, your legal fees are quite high. And it makes me, I mean, want to find out, why do you think it's high? Yes, this was what was agreed on. And when I find out, I noticed that my fellow colleagues, whether senior or junior, are charging a ridiculously low fee for the same legal service I'm offering. And, you know, that's the dilemma. I lose some, I gain some. We all lose some, we gain some. But the reason I can categorically say why I lose those some, in quotes, is because there's no standardization. There's no what they call it, there's no scale of fees, yeah, for legal services in Nigeria. Having said that, it's also a problem for the business owners within the MSME sector. It's a problem because sometimes I'm involved in their planning phase. I work a lot with startups, by the way. I'm involved in their planning phase for different projects, and they want to determine the price, the pricing, the budget for different services, legal services, accounting services, and all that. And because there's no scale, a lawyer here is charging like 1 million naira for the same transaction, maybe review of documentation or drafting of some legal documents. And lawyer B is saying, you know what, just bring 5,000 naira, we'll just review it for you.
The gap is that wide sometimes.
Is that wide sometimes? So that's the dilemma. How do they plan? How do they actually know the right fee, you know, with such kind of gap? So having said that, let's move to the existing legislation. We've been talking a lot about the LPA, that's the Legal Practitioners Act. We've also been talking about, I want to shorten the title for the second one, the Legal Practitioners
Remuneration.
Yeah, I'll call it the Remuneration Act order for the purpose of this discussion. So, and there's a third one I want to advert our mind to, and it makes me to align with the submission so far of the president of the Nigerian Bar Association. The first act I'll be looking at, section 15, subsection 3, subsection A of the Legal Practitioners Act, enjoins the remuneration committee to create like a scale for maximum charges. Well, I do not quite agree with the provision of that act, creating a maximum scale. I feel it's quite a no-no, looking at the fact that we are operating in a free market economy, as the representative of the Attorney General had mentioned. Then going into the legal practitioner remuneration and legal documentation, another like matters order, the entirety of the provision creates like a fixed charge and says transactions, legal transactions or legal services offered within a certain amount, would have this fixed charge. Also, I find that not too cool for the kind of economy that we operate in, as also the Attorney General had mentioned earlier. Now, going to the rules of professional conduct, we look at it. What has the rules of professional conduct got to do with it? Because I noticed we did not really, the previous speaker did not really touch on it, advert their mind to it, But there's a section 52, subsection D. It says that the lawyers should charge based on the customary fees obtainable in the profession. And that while paying attention to the customary fee, they should look at the minimum standard, the minimum scale as set by the Nigerian Bar Association. I embrace that, except that it goes on to say they may not take it and they may decide to consider other factors. Remember that under the remuneration order, they had outlined those factors that could be considered in case there's no provision for that particular legal services. They've outlined other considerations like the time spent in doing the work, the amount of documentation, the skill, the special skill knowledge of the lawyer involved. So they've enumerated those skills. But however, the NBA, the rules of professional conduct is saying, try to comply with the industry standards as the minimum standards by the NBA, but you may not. So it's kind of blank, it's not putting any standard as much. But the part I embrace is the introduction of the minimum standard. And I think it's something that NBA can take a cue from. And that is where my recommendation is coming from. Okay. If NBA is able to set a minimum standard that is transparent, known to all, it will help the MSMEs a lot. It will even help the lawyers, the young lawyers that are coming up, to be able to know, in order not to undervalue, because I believe that's the most important factor.
And 43% of our respondents agreed to.
Yes. I believe that's the major problem we are really facing, the undervaluing of our legal services. So I believe if a minimum standard is set, it will go a long way to preserve the dignity of the profession. Now, fixing a maximum scale that has been set under the LPA and trying to put a fixed charge, I don't think will work in a free market economy. It's advantageous. Now, the second part I want to talk about, the second recommendation I want to talk about, not quite novel, but novel to this discussion, is that I've observed that most young lawyers come out of youth service, after youth service, law school, after law school, youth service, and within 2 years of practice, they set up their own law firm. The question is, how much experience do they have in the business of running a law firm? How much experience do they have with engaging clients on pricing, on offering legal services? How much experience do they have? And I know that we did a bit of that in our law school courses. They tried to teach us on how to charge clients and all that. I don't think that is enough. I think we need to find a way to infuse, to include the business of the law, the business of running the law, it's not bad if it comes from the university level, because I'm also involved, as you know, you quite mentioned,
yes.
yeah. I'm also involved in an employment kind of social development work, Get Work Nigeria, where we help young graduates transit into the work environment effectively. So we help them with their employability skills, their entrepreneurship skills, and all that. So I believe it's something that should be introduced
Earlier.
to the upcoming lawyers as well, earlier, because I know there's this focus on learning the law and all that, but we need to consider this as much as it's affecting our dignity of our profession, as much as it's affecting our scale of fees. I think that there's a need to address it from the grassroots. That's lecturing, training the lawyers on how to do it better. Thank you.
Thank you very much,
Yeah.
Fumi. Thank you for those remarks. So we're going to go on to the last speaker, and we'll take our next poll. Is our poll online now? So our next poll says, what should charges for legal services be based on? The value of the underlying service to the client, the time and effort expended by the legal practitioner, the seniority, experience, and skill of the legal practitioner, or the quality of the legal practitioner's office. That's our next poll. Can we have everyone vote on that poll? I'm eager to see the results of this one. What should charges for legal services be based on? The value of the underlying service to the client, the time and effort expended by the legal practitioner, the seniority, experience, and skill of the legal practitioner, and the quality of the legal practitioner's office. Tola, are you online?
Yes, I am.
Hello, Tola?
Yes, I am. Can you hear me?
Hello,
Can you
Tola,
hear
it's good to
me?
see you.
All right.
Hello? Can you hear
Yeah,
me?
I can hear you clearly.
You need to unmute so that we can hear you.
I'm
Hello,
unmuted.
Tola.
I am not muted. I can hear you clearly. Hello?
You need to unmute.
I am not muted. I can hear you clearly. I'm not muted. I can hear you.
Okay.
Shola, can you hear me?
Tola is going to be standing in for Reginald Aziza.
Can you hear me? I can hear you very clearly. Can you just hear me? Can you just confirm me?
Tola serves as Assistant Chief Negotiator for Nigeria and Head of Trade Remedies and Investigating Authority at the Nigerian Office for Trade Negotiations, and is going to be speaking to us next. Do we have the poll results before we take Tola? Okay, you're right. What should charges for legal services be based on? The value of the underlying service to the client, 54% have voted for that. The time and effort expended by the legal practitioner, 40%. The seniority, experience, and skill of the legal practitioner, 16%. And we have no votes for the quality of the legal practitioner's office. Tola, I'll come to you now. Having listened to our poll and the results, the question is, what do you think? Do you support the establishment of a scale of fees for legal services? And what do you think is the best way to calibrate them, having seen our poll results?
Thank you very much. All right.
Hello, Tola.
People can hear me clearly. I think you're the one that can hear me. Everyone else can hear me.
We can't hear him. Okay.
Can you hear me? Can I keep
I'm
going?
told that attendees can hear.
We all can hear Tola. Save Shola.
Shola, I think you're the only one that can't hear me, so can I go on?
Go on, Tola.
All right, fantastic. Thank you very much for the invitation to speak. This has been going on for 13 years, so I think it's best to start by sending a very hearty congratulations to the SPA Ajibade team for putting on this lively conversations about the future of our legal system and what the design should look like on a consistent basis. So I'm going to jump in very quickly. So the first thing I think is best to start with is to say that the conversation so far today have shown a very clear understanding of some of the important issues. And one of it is the need to maintain a form of flexibility for legal services in the country. So the thing with a country like Nigeria is that across the different geographical locations, there is a varying range, a wide varying range of what the power to spend for legal services looks like. And like most economies, because legal services is a services one that doesn't seem to a lot of people, except it's a criminal case, to be a life and death issue. What you find is that there's still not a massive adoption of legal services on the country. I once read a poll once that says that less than 95%, less than 5% or so of Nigerians actively use a lawyer for their day-to-day transaction on a regular basis. So meaning, I think the question was basically a random poll sampling that's asking if people had lawyers. And the problem with that is that you immediately have a system where there is not a deep enough market for legal services and for lawyers. And so what you start to have is a case where, because there's no deep enough environment for lawyers, everybody charges the same. Most of the big lawyers are servicing the same clients. And okay, I think you can hear me now. Most of the big are servicing clients. But beyond that is also the fact that you have cases where, in places where they're not big clients, there's a massive case of undercutting where people are paid a lot less than you would expect. And so the question you ask yourself when you bring up the issue of the scale for charges is what exactly solve for? So I find that what you're trying to solve for is two cases. One, you're trying to ensure that people who are on the spectrum of charging high are not overcharging, but you're also trying to ensure at the same time that those who are charging low are not being undercut. The problem is that when you look at a place like Nigeria, where there's Lagos, and I'll use some of the scenarios that NBA presents, it becomes difficult to come up with a standardized system for determining what costs should look like across board. Also, when you put in context the fact that it's really hard to update a scale of charges periodically. So for instance, the scale of charges we have now has terms that are not, yes?
Hello, Tola. If you can hear me, we can't hear you here. So I'm going to pause you for now and come back to you later while we try to work out the technical issues. We can't hear you here.
But the public can hear him.
I think you're
Hello,
the only
Tola.
one that can't hear me, Shola. Shola, you're the only one that can't hear me. Everybody else can hear me.
Do we take the video and come back to him? So we're going to play a short video and then come back to him. I can't hear him here, but we'd really like to listen to him. So
Shola, this is Raymond. Can you hear me?
All right.
Yeah, we can hear Tola, but Shola needs to
Shola,
hear
can you
him.
hear me?
She's the moderator.
The issue is now is whether to expand the rules beyond that level to cover other areas of legal practice. Of course, there is a scale of charges at the moment. However, the question is, how effective is that scale of charges? Are lawyers making use of the scale to charge their clients for? And I think the scale of charges that we have is in respect of property, leases, and section 51 of the RPC, leases and sale of property, right? So it does not cover other professional responsibilities and all that. So, to my mind, scale of charges, scale of property is fair enough for in respect of properties and leases and sale of property. However, in respect of other areas, litigation, consultancy, and other legal work, I don't think there should be a scale of charges because already we all charge our clients based on what we think the client can afford. And while I can have a client who is ready to pay me 20 million to prosecute a debt recovery matter, another client, can be ready just to pay 2 million. So it's because of its very nature. I think in that area we shouldn't have much of regulation.
Well, yes, I believe that for the legal profession, there should be a scale of fees applicable to certain transactions, scale of fees applicable to certain practices. This will not only help in determining fees by lawyers, it will also help clients to have an idea of what they cost before venturing into certain transactions. We've had situations when clients will tell you that this is what they are looking at in paying as fees, and then the lawyer is also charging another thing. But I strongly believe that there should be a scale of fees for transactions for lawyers.
No, I don't think so because most lawyers these days, they don't use it. And ever since I left the law school, I don't think I've ever used the scale of charges, charging my clients. The amount, whatever, in any deal that you do, if you're using the scale of justice, that means lawyers will be cheated, the scale of charges. So it won't be fair or not. The best thing is just like other people take percentages, 10%, 5% out of every deal. I think it should be preferable that way.
Well, I feel already the framework that exists sufficiently protects indigent clients. There is already a requirement that lawyers that want to apply for silk must do a number of cases of pro bono. There are a lot of non-governmental organizations formed by lawyers that
the legal aid
do cases for the societal less advantaged people. So I believe those people's interests who are genuinely in need of legal services but are unable to pay for those legal services, those people's interests have been sufficiently protected in the current framework.
Yeah, I think there should be scale of charges, set minimum amounts lawyers can charge for certain and simple transactions. But I don't think it should be mandatory. I think it should be persuasive. I don't think the scale of charges will be able to capture, all kinds of transactions, especially peculiar transactions. I don't think it will also be able to capture complexities that arise in certain kinds of transactions. That's what I think it should be.
We have that the provision in the RPC is a loose guideline on how to charge professional fees, and the looseness of it is actually the problem. Different people can hide under the provision to charge any amount. I think what we are saying now is a kind of shift to make more specific provisions for case-specific charges. But in that case, we need comprehensive rules that will be capable of being monitored. But the other side of it is that there are some structures that ought to be in place before we can talk of such. If ever there will be a scale of fees, I think it should apply only in commercial transactions. Because commercial transactions are a kind of will I be right for me to use the word sui generis or something? Because they are in a class of their own, and the fees that are paid with respect to some of those transactions, leaving it unregulated could make a counsel, some lawyers, overzealous in charging their clients. Unlike if I have an election petition matter, unlike if I have a property dispute matter, land matter that are huge, like acres and acres of quantity. So in that regard, the scale of fees applying in that regard can be a bit unnecessary. But in capital market transactions, as well as other commercial transactions, there is definitely a need to regulate, at least for profit taking on the side of the clients as well.
I do not believe it should cover all areas of law, but I believe it should cover specific areas of law, especially those areas of law that the extant scale have become obsolete and needs a total overhaul or review. For example, we talk about scale of fee when it comes to real estate practice, because the scale of fee that the economic reality that we have nowadays.
Yeah, I don't think the scale of charges can do it all. I don't see the practicability of having specific fields for certain kinds of transactions. Because in everything, complexity will arise in certain kinds of transactions, and I feel that lawyers will have the freedom of being able to choose the amount they can charge a particular client to an extent, depending on your capacity and the capacity of your client, which is also a factor in business.
My problem, if we can have a workable, enforceable scale of fees, I'm for it. But the challenge really is how to effectively monitor and enforce those rules. Don't forget
Okay, I should
the
unmute
rule we
myself.
have for scale of fees, legal documentation. I've never seen it enforced. I've had cases of people charging different amounts for same size of land, same consideration, different lawyers charging different amounts.
I think a scale of charges can be enforced. I think it is enforceable. If we can enforce things like, if we can enforce things that have to do with appearance, like the way we appear in court and so many other things that I do not think are so important. If we can enforce all those little things, I think we should be able to enforce something as important as our fees, which is the reason we go to study law in the first place.
Welcome back, everyone. That was a short opinion video on what lawyers think about the necessity for a scale of fees. Now, Tola, we'll come back to you. I believe we've sorted out the technical issues. So the question is, on the scale of fees, what do you think is the best way to calibrate such a scale? Do you think it should be ad valorem, that's based on the value of the service to the client? Should it be hourly rates? Should it be based on the amount of time expended on providing the service? Or should it be a lump sum based on, at best, a judgment assessment? What do you think?
Can you hear me now? Hello, can I keep speaking? All right, can I continue speaking? I just want to confirm.
Yes, please go on.
All right, fantastic. So what I would say is, I think like I said, like I was saying before, the technical glitch the last time, the first thing you need to put into context is that legal fees in itself are very much controlled by an issue of privity of contract between the different parties, right? And so in the end, what you want to create is a system that ensures flexibility and incentivizes the different parties to play their part. There's a very popular principle in economics. It's that you cannot regulate the behavior of independent parties acting in their own self-interest. And what that means is that the client will always look for a way to pay what he thinks is the most reasonable for his fees. And lawyer would always try to look for a way to get the maximum fees out of any transaction. It's just what it is. It's economics. It's basic economics. And any regulation that depends on the good behavior of people for it to work never works. You need to use incentives. You need to use the systems that actually already work. So what that means to a great extent is that the most important things in designing a scale of a scale of charges is actually the idea of flexibility. You need to create a system that is flexible enough to capture the diversity of all the people involved. Don't forget also that we're talking about Nigeria, where the geographical location and the depth of the market means that people's willingness and ability to pay in different locations differs. So I think one great example to draw from is what the Ghanaian Bar Association has. It's not a perfect system, but I think it's a big progress from where we are. Now, what you want is, and so what the Ghanaian process has done is, it's not even an ad valorem, it's not a fixed fee, it's not a lump fee, it's a mixed match of all of them. In some places, he makes a proposal for a lump sum. In some places, he makes a proposal for a ad valorem charge. In some places, it makes a proposal for fixed charges. But one thing he also does is that it provides ranges. So one thing that you would see when you look at the Ghanaian one is that it does two things that I find very interesting. First is that it actually focuses on years of experience. So it says, based on different years of experience, it actually allows a flush. So it says, for instance, a senior associate is going to charge a lot more than a junior associate, a partner, and it does that flush. The second thing it does very interestingly is that it actually separates the fees that a foreign client, you would charge for a foreign client and what you would want to charge for a local client, right? So it says, for instance, an international client, you can charge in dollars. The third thing it does that I find very interesting, that it actually gives a range. So instead of saying things like $2,000 maximum, it will tell you things like between $2,000 to $10,000, or between $5,000 to $25,000. So it gives a flush, it gives a band within which lawyers can actually pick what is most fitting for them. Two things to also put in context, even as we start to design our own system, is that one, you've got to realize that the more you restrict a scale of charge, the more you have to actually start to amend it as time. Because the truth is, as time changes, as currency devaluation happens, which the Nigerian currency has lost 25% in the last few months, it means if you put a very tight band, you're going to have to review it too regularly. And that's not effective lawmaking. So what you want to do is create a broad enough band that covers for a range of spend, right? And gives a flexibility to lawyers to pick what is most favorable for them. It also allows people to be able to pick what works for their different locations. It allows a mixture of what is most important. The question you also want to ask yourself is, what are we trying to cure? What you're trying to cure is, you're trying to cure a situation where people do not charge excessively, or people do not understand. And one problem I saw with the Ghanaian system that I think we also have to work is the fact that it says it gives a distinction between foreign clients and Nigerian clients. So when you look at people like Chevron Nigeria, or Mobil Nigeria, they would qualify as local, right? So the problem is that the band for which you can actually charge high on that deal is a lot lower, because you would have to take Chevron Nigeria as a Nigerian client, and that changes. So it would also mean that you have to critically think about how you also determine that echo. I'm echoing. If technical guys can work on that, I'm echoing and I can hear myself. Thanks. Yeah. So the fact is that band also has to be creative about how we think about that band. The second thing to say also is that we need to be careful to ensure that flexibility is clear, because like I said before, you cannot compel the behavior of economic actors acting in their own self-interest. You cannot regulate their actions. So what you want is flexibility that allows them pick what works the most for them. But three issues that will still come up regardless. One of the things that will come up regardless is the problem of enforcement. How do you enforce? Even if you design this, how do you enforce? So the truth is, and that is also a reason, what we should try to do is pick out incentives, meaning give a flexible band, allow people pick what works for them within that flexible band. Because the truth is that if you pick a very tight band, what happens automatically that people will go on the ground. What will happen is cases where people try to avoid the regulations, people would come up with arrangements with clients to evade it, and enforcement becomes incredibly difficult because of the right of privacy. Meaning, I can't tell you bring all your documents. Let me review how much you charge a client. It's just problematic. So the truth is, what I think we should be leaning towards is three things. One, incentives. Pick something that people already works within their interest. Two, flexibility, meaning a broad enough band that mixes charges in some places, that encompasses lump sum in some cases, that encompasses ad valorem charges in some cases. That mixed match is what I'm looking for, because that allows flexibility for people to pick what works the most for them. And we have to be careful to ensure that even in doing all of this, we preserve what I'll call the free market interest. Because the truth of the matter is that in the end, these are economic actors. Clients are looking for the best price. And don't forget, in a free market, people vote with their money and their feet. Meaning, if the price is too high, clients will walk. And if the price is cheaper somewhere, they will look and pay for that. And so we need to also be careful that we don't clip the capacity of lawyers to earn, or we don't make them uncompetitive, because in economics it's called the theory of the inefficient producer, which is that if you prop up a system using regulations, right? If you prop up a system using regulations, one of the things you would have is that because of that, it will be impossible for people to be flexible and to compete. And the other thing to say is that we also need to create a flush system that accommodates system. I think an example tries it a lot, but I think we can do a lot more. But even how we provide that for people based on their levels of experience, people based on their location. But I think what you want really in the end is the truth of the matter is that when you start to get into the detail, you start to manage how lawyers actually charge. So what you want is that it's banned. For this service, you can charge between $2,000 to as high as $20,000. People can pick within that band who works for them. So you're basically saying, what's the minimum threshold I think is fair, and what is a maximum threshold? So that's what you're doing. So rather than saying you're trying to be exact, you're looking for thresholds, you're looking for spreads that people can work with. The problem with that, regardless, like I said before, is that you still run the risk of creating an underground industry where clients will say, for instance, employers say, for instance, give me whatever you want because now I want to undercut other lawyers. And that's something you cannot eliminate by regulation. You cannot enforce it not to eliminate it. And so what I say in the end is we need to think around how we use incentives more creatively, but beyond using incentives more creatively, create flexibility in the system that ensures that we don't have to change the regulations every other day. People, regardless of where they are playing economically, and allow their clients pick what works the most for them. And people can be competitive even when doing deals with international clients. Because like I said before, if you use the Ghanaian example, the exact way it is designed today, a lot of our big law firms will not be able to charge in a way, or even on the international deals that they do for people like Chevron and the rest, because Chevron will claim I'm a domestic client, and so because of that, you have to use the other. So I think rather than using the word domestic as international, I think we should be using maybe an earning power. I don't know, but we've got to think how to use that. But like I said, flexibility, using incentives, and then ensuring that you're recognizing the fact that these are economic actors who will pick what is best for themselves. And so you allow them that flexibility and that freedom to do what they think is right for them.
I'm going to go back to our poll. Do we still have the representative of the Honorable Attorney General with us? Hello?
Hello.
Como, are you still here? Good, great. You see our first poll and the results. I'm going to read it. And I'm going to start the Q&A with you. On our first poll, we have this question. Do you think a comprehensive for legal services in Nigeria will be useful? And 144 people voted, 84% in favor and 16% against.
Hello, moderator. Can you hear me?
What do you make of the results of this poll?
Sorry. Please call me. Hello. Please ask the question again, please. Okay. Please come again. I did not hear the question. Hello, moderator.
Yes, do you want me to repeat the question?
Please do. Please do. I did not hear the question.
Speaking, and we asked the question, do you think a comprehensive scale of fees for legal services in Nigeria will be useful? We had 144 people online who voted and participated in that poll, and 84% voted in favor of wanting a comprehensive, they say that a comprehensive scale of fees for legal services in Nigeria will be useful. 16% voted against.
Well, judging by the result of the poll, majority or all of whom I believe are legal practitioners, it will appear that majority are in support of having a comprehensive scale. But that is not to say that the majority is in the circumstances. So, like I said in my earlier speech, the Attorney General is at the moment considering a holistic reform of relevant laws to ensure that the legal profession is properly developed in accordance with the realities of the day in Nigeria. So when this is going to be done, eventually, all stakeholders will be considered at that time. It is possible that the participants at this event are people of the same view, of the same mindset on the subject matter. So in coming to a conclusion on this kind of important subject, it is important to have a broad spectrum of stakeholders' views and come to a realizable, workable position that can be implemented. You know, like majority of the speakers have said, it's not enough to just have laws. Laws in themselves do not have automaticity. Laws must reflect the reality of the society. So the takeaway or my position as representative of the Attorney General on this is that, well, the process is ongoing to review the relevant laws, not only on the scale of fees, but to make the law profession more effective in accordance with the realities of the day. And when that will be done eventually, the views and the position of all stakeholders will be considered. Thank you.
Any views on when? Do we have anything as to when? Because you say that the Attorney General is considering this. Do we have anything about activating the Legal Practitioners Remuneration Committee? Do we know when this will be done?
Well, by the word activating, the committee has been set up by law already. The members are known. What is important is whenever there is need to have a meeting, members to be called upon. So activating presupposes that the committee is in excited to, when it is necessary to have a meeting or a discourse by the committee, of course the Attorney General will
that if we have of our respondents saying that there is a need for a scale of charges, I think that makes it necessary for the committee to meet and think about this issue and put it on the front burner. Don't you agree? And get more comprehensive views from more stakeholders like you have suggested.
The Attorney General is duly represented here. the outcome and the discussions at this event will be communicated to him. Yes, and Nigeria is such a vast environment, so the rightful thing will be done.
Still have the president of the NBA with us.
Shola, I'm still here.
Mr. President, are you still here? Great. Mr. President, our poll results, the one I just read out, 86% think that it is desirable. 86% of our respondents think that it is desirable. Of the legal community, think it is desirable to have a scale of charges. As a member of the remuneration committee, is there going to be anything done to at least put this on the front burner about it and start to get more consideration from a widespread, from all stakeholders, so that we can move forward and find out what the legal committee really needs, really wants, and then start to do something in this regard?
Well, absolutely. Well, I definitely agree with the 80-something plus respondents in that poll that we definitely need a scale of charges. And you can be sure that I will use the opportunity of my membership. Shola, are you able to hear me? Shola, can you hear me? Well, Mrs. Etin, can you hear me?
We can hear you, MBA President.
Shola, you can hear me? Okay, great.
Yes, I can. I think we all can hear you. I think Shola's.
I can hear you, Mr. President.
Okay, great. Let's proceed.
Mr. President, I can hear you.
Okay, we'll just go on. Thank you very much, everybody. So, Shola, I was saying that I definitely agree with the respondents on that poll that we need a scale of charges. And also, I will definitely use the opportunity of my membership of the Legal Practitioners Remuneration Committee to ensure that that happens speedily, that happens ASAP. Having said that, what is important is that the NBA, let me apologize, because obviously, for some reason, I didn't get prepared. The format was one of the discussion style format. But all the same, I will share with you the speech that I prepared and I read partially. I will share with you so we can send that to those who have attended. Because I think it's very important. What the MDA would like to see is a realistic scale of minimum charges for all legal services. And just as Raymond Mboko mentioned, it is something that must be thought through. We must think it through because issues are multifaceted. We must be able to contemplate all of it, which is what the MPA is doing at the moment. Because we have to contemplate the encounter in implementing and enforcing a scale of charge. And as I was alluding to in the course of my address earlier on, the first thing we need to do is to define, expand the scope of our exclusive services, and then we'll defend ourselves by ensuring that there will be consequences for non-compliance. If we are not able to do that, any scale, minimum, maximum, or like Tola, my brother has proposed, one that is the floor of upper and lower limits, will be dead on arrival. It's important for us to know what it is that we do and how we do it, and the fact that it is our exclusive reserve to do that. You know that if we prescribe a scale of charges it can also mean that we'll be shooting ourselves in the foot, because you run the risk of the client hugging that minimum and insisting on paying only that minimum. So we must also watch out in determining how we do that to ensure that not only we give the client the incentive to pay more than the minimum, we also are not disincentivized in a way that we now only give minimum charge. And at the end of the day, we are not inspired to do more because the client is not willing to pay more. So it could be a double-edged sword. We must think through. Now, essentially, what I'm saying is this scale of charges, potential challenges. We must contemplate what it is. How do we want? What are the indices we want to? Should we take into consideration the type of work, location of the lawyer, experience level, indeed, cost of socio-economic factors must be taken into consideration in the process. And then even if we are able to get the design right, everybody, I think all the speakers have already mentioned the fact that enforcement remains the bane, remains the issue. How do we enforce? Letters of engagement between lawyer and client are private non-registrable contracts. And the NBA would have no way of knowing whether there's compliance. Enforcement will continue to be an issue. One of the solutions we're contemplating, Shola, really we need to talk to the revenue, to the taxman, to ensure that if the lawyer is charged, that lawyer ought to pay in terms of value, VAT, and other returns to the taxman. That may be a solution to ensure that if the lawyer does not charge the minimum, he or she would have to pay out of pocket whatever that minimum represents in terms of remittances to the revenue. As crude as that might sound, that might be one way of ensuring compliance or enforcement. So that's one of the things we want to look at. So essentially, what I'm saying is that the NBA is currently contemplating all of these issues. And we will work firstly internally, and we are designing a scale that we think will work. And then I will, in my capacity as a member of the remuneration committee, present this so that we can take on board other views to that committee. Indeed, we have set up codenamed Project Benjamin. And we're going to get our members together, subject matter experts, so that lawyers will be able to charge right fees for their legal services, and also ensure that those fees, when earned, and Shola, this is very important, when the fees are earned, that there will be a trickle down in terms of reasonable living wages and emoluments to those who work with and for the lawyers. We think that these two issues, earning capacity of lawyers and law firms and the ability to better remunerate their employees, are inextricably linked. So we have to take care of those two. So we're going to be working on both issues. Scale of charges, yes, so that lawyers can earn more. But we want to make sure that not only do lawyers and law firms earn more, we want to make sure that lawyers and law firms pay more and pay their workers, their lawyers better. So I am confident that we will get the we will get recommendations from our members. We will take away all that we have talked about at this event, and we will that's about it for me.
Thank you, Mr. President. I can hardly hear you, but I believe that our participants can. And I know that I heard you say, even if faintly, that you will work on it. that you're committed to doing something about it, and that you will consult more widely and put it on the front burner. I think I heard that part, but I'll come back to you. And I also heard you talk about enforcement. There's a question for the FC. There's a question from Ishak Obashola Akpalando to the FCCPC, Federal Consumer Protection. Don't you think that Section 15 of the Legal Practitioners Act is special law which derivates from the FCCPA, so that some of the provisions of the FCCPA and subsidiary instruments made thereto may not apply to lawyers? I believe that's a question for you, Ms. Ojugo.
Hi, Shola, good afternoon. So
FCCPA.
Yes, can you hear me? Okay, I'll just go straight to it. So I'm not going to go into interpretation of the law, but I need us to understand the objectives of the FCCPA. Basically, the law was enacted to maintain, protect, promote economic efficiency in Nigeria. So the application of the FCCPA cuts across board, across all sectors of the economy. So if you seek to exclude a certain sector or a certain act or anything that is within the scope of the law itself, I think that will actually be counterproductive, because when we get the economy to work, both for lawyers, consumers, and everything, everyone is going to benefit from it. And like I said earlier on, the commission in itself is not per se against fixing a scale of charges. What we would love to do is to ensure that the nature of that scale, its objective is not to inhibit competition in any way, because the law goes on to say that the commission encourages activities of associations that develop and enforce standards of professional qualification. So if the scale of fees is to enforce, to standardize behavior among legal practitioners, I don't see why the commission would want to come against that. But seeking to exclude the legal professional, Section 15, seeking to exclude the application of the FCCPA across board just doesn't cut it, because going on into the law, in Section 167 expressly mentions the Legal Practitioners Act. So that particular act is also recognized in the law itself. So if the association can approach the commission, okay, this is what we are doing and this is how it is, the commission would provide guidance on ensuring that it's not anti-competitive. So you can't just seek to exclude Section 15 or seek to exclude the application of the FCCPA from...
Thank you. I'll come back to you, but let me come to Bumi. I have a question for you, Bumi. This question is from Laolu Babalola platform online. It says in January 2020, Naira was 359 to the dollar. In December 2020, it is 501 to the dollar. With this unpredictability, is it viable or beneficial, especially to the lawyer, to have a fixed scale of charges when the economy is topsy-turvy?
Okay, I think one point I forgot to mention when I was saying that when I was talking about the minimum scale of charges as recommended by the rules of professional conduct, there's a need, if MBA can actually publish a minimum scale for lawyers and have it reviewed, have a review committee that review from time to time in line with the economic situation, I think that will resolve that particular issue. I think it's possible, it's viable. If there's a review, consistent review, might be like biannually or annually, based on the current economic situation. So it's not a fixed charge, a minimum scale. I embrace a minimum scale because I believe that the major problem is the undervaluing of our legal services. If most we agree majorly that is the problem, then having a minimum standard will resolve that.
Okay, I want you to also weigh in on this question from Olaide Dara. It says there's an area not looked into. It's the issue of using relationship with clients to determine the fees charged. How do lawyers deal with this? For example, an uncle wants to prepare an agreement. He wouldn't want to pay 10%.
You see, that's the major issue. We are enjoined as lawyers to deal professionally. In fact, there's a maxim I see business people put up that if family and friends pay, then we will succeed. So why should you, as a lawyer, undervalue your profession just because a family or friend is not ready to pay the minimum standard, the minimum scale of fees? And that's where the problem is. That's why someone would agree to do the same work that another lawyer is doing for 1 million and would agree to do it for 5,000. In fact, that instance I was actually citing is with respect to a family friend and a relative. But we must seek at all times to protect the dignity of the profession. Shouldn't be to the disadvantage of our colleagues and peers in the profession. Yeah.
I'm going to bring you in Mrs. Etim and Mr. Ngwekore and Adetola. I want you to go one after the other. Victor Wakasi says, what is the enforcement strategy? That is largely what we need. Enforcement. Let's talk about enforcement. Mrs. Etim, can we hear you first?
Yes, I can hear you, and I hope you hear me too. Hello? Can I go on? Can you hear me, please?
Yes, we can. Please go on. We can hear you.
All right. Okay. I earlier on cited an instance, for us to be able to enforce, we must first ensure that lawyers are properly remunerated. Like in the instance I cited earlier, where a lawyer in Ghana under the same scenario would earn almost 200,000 under the scale 1 of part 1 of the legal practitioner's remuneration and legal documentation order. A Nigerian lawyer would earn graduatedly, for example, for the first 1,000, 100 naira of 1,000 naira, 22 naira 50 kobo. For the second and the third, a Nigerian lawyer would earn 11 naira 25 kobo. For the fourth and subsequent ones, up to 20,000, every 100 naira of 1,000, a Nigerian lawyer would earn 3 naira 75 kobo. And going forward ad infinitum, the Nigerian lawyer earns 2 naira 80 kobo. I actually calculated this, and I found that for a property worth 1.3 million, a Nigerian lawyer earns 36,000 naira maximum. That is grossly underpricing and undervaluing the lawyer. So coming to the issue of enforcement, a problem I saw there is that the order itself does not really provide for that much of punishment, even though it says that, it simply says that whoever contravenes the order shall be guilty of professional misconduct and shall appear before the disciplinary committee. Now, professional misconduct in itself is not defined in that order. And then you go to the legal practitioners.
So what do you suggest? You said that the section does not envisage this. What do you suggest in terms of enforcement?
In terms of enforcement, first and foremost, like I said, before we enforce, we must be able to take care of the lawyer first. Because in this case, what are we going to enforce? If, for example, in the scenario I painted, a lawyer is earning, as opposed to 200 from a lawyer earned by a lawyer in Ghana, a Nigerian lawyer earns 35,000, and he's been dragged before the disciplinary committee. It is the disciplinary committee that will decide. How do you decide this? I think the first place to start is to make sure that the laws that we reform the laws, at least to take good care of the lawyer in terms of charging. And when that happens, and the lawyer still continues in the contravention, because like I said, the unfortunate thing here is that it is the lawyers themselves that are contravening the very laws we set for ourselves. So in my opinion, the first and the best place to start is to make enabling laws that would enable lawyers, as I said, charge within a range, not necessarily a fixed rate, look like a percentage, as I saw there I said in the Ghanaian law, you negotiate with the client within this range. And if at the end of it, a lawyer does not, then we can talk of enforcement. How do we enforce? Then the stringent laws here can come into play. Because in any case, the laws here in the 1991 order makes it non-negotiable. It is compulsory. So I don't see any problem. The only reason we're not able to enforce is because the laws providing for the fees themselves are not tenable at all. And that is why there is that broad disobedience.
Thank you, Mrs. Exim. I hear you talk about reforming the laws. Thank you very much. I want to bring in Adetola. Adetola, are you here with us?
Yes, I am.
I want you to speak to us also about enforcement. There's also this question from Mr. Victor Barrow, who says, the critical question is whether the scale of charges may extend to the rank of SANs. What are your thoughts on this?
And that's what I said in the first place, right? So, I think it's important to start. I'll start with a story. So at the beginning of the lockdown, the South African government passed a regulation that actually banned smokers, that banned the sales of cigarettes, right? What you saw happen was that during the lockdown, the price of cigarettes shot up, right, 4.4% every day. And by the end of the lockdown, it was about 250% up. The problem with regulations that do not align with incentives is that you create an underground economy and you give people an incentive to actually try to evade it. So like I said before, first is I am very anti-regulation. I'm for light touch, more traditional. I feel like our focus should be less about regulating fees charges and be focusing more on deepening the industry. But if we decide to go the route of fees charges, I say be flexible. Accommodate for what the SCNs will want to charge. Like give a ban for the SCN. So if you look at the Ghanaian document, it says things like associates this price, junior associate this price, senior associate this price, partners this price. So my point is accommodate for that. Plan for a system that allows for flexibility for these people. What that does is that it ensures that they already feel like there's an incentive for them to accommodate and cooperate with it. And so there's no need to try to evade it. If you create a system that restricts them, we're going to have the CBN policy all over again, where people are going to be trying to avoid the rules. On enforcement, I still think it's going to be incredibly difficult to enforce because let's not forget that if a client and a lawyer agree together on how they want to design something, it's going to be incredibly difficult to actually find out evidence to prove that they were underpaid. Even when we use the tax, if I say my client hasn't paid the balance, will the taxman charge me for the balance I've not received? The truth is, there's a million ways to play around it. So the truth is, in the end, your best course is to go for an incentives-based system that aligns with what people are comfortable, what clients and lawyers are comfortable with. Create a band of flexibility. Say, this is the threshold. In fact, I'm saying this is the minimum. This is a crazy high maximum. Give people that flexibility to play around and pick what works for them. That way, you're guaranteeing that people are not undercut. You're also ensuring that people are not excessive, but make it a healthy band. Right, and do a mixture. There are places where you do fixed fee. There are places where there's a merit to fixed fee. Places like consultations, there's a merit to fixed fee, right? There are places where there's a merit to lump sum. There are places where there's a merit to creating an ad valorem system. My point is, give people the flexibility to, and also allow them say, I don't want to use this system. I want to go on my own. The truth is, in the end, as long as you give people the flex, and I remember, like I said before, it's a popular economic principle. You cannot regulate independent economic actors acting in their own self-interest. It's just what it is. And so you must make regulations that do not rely on people's good nature, that do not rely on people's patriotism, that relies on the fact that these are economic actors and will do what is best for them. And so allow them the flexibility to do what they want to do while trying to cure what you're trying to cure, which is undercutting. I think our biggest problem in the market today is not overpricing. It's actually undercutting. It's that in some interland, in some rural areas, and in some non-deep legal markets, lawyers are massively undercut. So the question we should ask ourselves is two questions. One is, how can we ensure that we're creating more interesting legal system and more interesting legal products that can service all these people. The second thing we should be thinking around is how do we deepen this market? How do we create an interesting way for people to pay? And I'll say something that I was going to close with. I'll say it. There's already conversations about legal tech, about commoditizing legal services, about having apps, having artificial intelligence do legal work. I'm invested in a company that is doing things of that sort. There's already conversations about creating minimum products. How exactly do our legal scales of price, how would they work in that? If an AI is doing my legal advice work for me, it has codified all the laws and can give a quick opinion. How do you determine what the legal fee should look like in that instance? If I'm commoditizing legal services and saying opinions are $20, whatever it is, how do you apply legal fees to that? How do you apply the scales of charges to that? So my point is, your best shot, like I said before, because enforcement is still going to be incredibly difficult because a client and a lawyer would agree on what they want. So what your best shot looks like is creating a healthy band that allows people to choose to elect not to apply the system, but even if they choose to apply the system, allows a healthy band of flexibility that accommodates the different geographical places, the different economic peculiarities, and the different levels of experience of the different players, recognizing that they're economic actors and they should have full independence and full right to choose the terms that govern their transaction.
I believe you've answered Mr. Olumide Ajayi's question. He says, how do you give a general scale of charges considering the different cost of living in various parts of the country? Let me bring you in, Mr. Igbekwere. Having listened to all our panelists, having listened to everyone and the questions, what do you think at this stage with regards to enforcement and how we move forward?
Thank you, Shola. I think Tola has said so much what I would love to say. And I'll start by saying, in addition, that one, when I made my earlier remarks, I did say that beyond being dogmatic about scale of fees, we professionals and lawyers should introspect a bit more, question ourselves about how to give value. Like Tola said, in some jurisdictions, a lot of agreements are already commoditized. Tenancy agreements in the US, people just log on and print it out and sign it online, and that ends it. So, and people, all of us on this call, we are lawyers. What we pay for is service and value. It's not about struggling about codification. So when we do what we need to do and it ends that we must codify, then the next question is, codification has to be a very deeply thought out process. And like I said before, we have to start all over again. What we had in 1991 cannot stand today's realities. It was a very basic, routine, and rudimentary instrument and did not contemplate the sophistication we are seeing today and the change we know will happen tomorrow. So the agency, like Tola mentioned, and I hinted initially, no defaulting lawyer will self-report himself. You will need to create a system that compels lawyers and legal practitioners and law firms to file returns and reports to a body. That body must have right of access to the law firm to offer, and the much MBA has done in regulating and pushing us to pay our annual practice fee at the branch level and the annual level to get our stamps and everything. Not much happens to our registry. Lawyers practice as they want to. Nobody knows what they do. Some lawyers don't have offices. And you need to think through this totally before you can say, let's go for a structure. That enforcement will come when you have compliance that has a framework, that is from compliance that you see there's a breach, that you see enforcement mechanism, that you see punishment. And like I said, don't forget, this is not a case of a bank that has a CBN that regulates it and punishes it, or CBN makes a rule about what you charge in a transaction and it binds both the staff, both the bank and the customers. In this case, we only have ability to regulate ourselves and not the clientele, like Tola mentioned. So once we are willing to play the game of evading or breaching this rule of ours, the client is very happy to welcome us and is a very happy participant in that breach because he loses nothing and gains so much by saving so much money. So it ends at professional self-regulation. Asking ourselves, do we want to leave a market that impoverishes and pauperizes lawyers, or want to create a market that lawyers are proud, the way we thought about it when we went to read law, want to leave the market better than we met it? And it also goes to remuneration of lawyers. If a lawyer in a firm earns 10,000 naira a month, and he sees a transaction that his firm can negotiate at the scale we agree, if he pays well, and at the end of the day, he doesn't get anything from that transaction because the firm doesn't pay him well, he'd rather take a 1/10 of that, which is better than what he earns, and signs off and then does the paper, and he goes away because he has no better option. So it's a total industry rethink and reset. And I'm believing that I wish we had seen all that the MBA president had to tell us or his paper. I'm sure there are deeper thoughts there, and we all are participants in different segments. When this rethink will be done, it's a total overhaul, and we would go through it and create what needs to be done. But as it stands today, what we have cannot deal with anything. Thank you.
Intervention. I'm going to bring back the president of the NBA, Mr. Olumide Apata. I want to read out this comment from Favor Njoku online, one of our participants online, who says, okay, it's an opinion. She says, this isn't a question, but an opinion. I believe we can achieve the scale of charges if we set same based on jurisdiction, just as we see in our filing fees across the state high courts. I suggest for properties ranging between 4 million to 10 million, professional fees of 2 million naira should be paid. We can take a cue from the Lagos State High Court filing fees. We can also make it compulsory for a proof of payment to be sent to the branch in order to obtain a particular type of seal, which can only be used for land-related transactions. She's just giving an illustration there, without which documents cannot be accepted at the lands registry. This is one of our participants throwing up a suggestion. I also see people online asking you to furnish us with a soft copy of your speech. Okay. Mr. President, I want you to respond to that suggestion from one of our participants online. Is based on jurisdiction, just as we see in our filing fees across the state high courts. She thinks that this is something that can work. Mr. President, online.
While we wait for the president, can I make a comment on that just very quickly? Okay, the president is here. Sorry.
Mr. Mr. President, did you hear me? I have a suggestion from one of our participants online, Favor Njoku, who says, I believe we can achieve the scale of charges if we set same based on jurisdiction, just as we see in our filing fees across the state high courts. I suggest for properties ranging between 4 million to 10 million, professional fees of 2 million naira should be paid. We can take a cue from the Lagos State High Court filing fees. We can also make it compulsory for a proof of payment to be sent to the branch in order to obtain a particular type of seal, which can only be used for land-related transactions, without which documents cannot be accepted at the lands registry. These are people throwing up suggestions of what can work. What do you think?
Thank you, Shola. Can you hear me?
We can hear you, Mr. President.
Great. So, Shola, I heard the tail end of your question, but I think all suggestions are welcome. And I think the principle going forward is that whatever scale of charges we are able to design must take into consideration such the socioeconomic realities of our practitioners. So yes, scale of charges must take into consideration where the lawyer is practicing. Yes, scale of charges must take into consideration the complexity of the matter. Yes, scale of charges must take into consideration the expertise, the qualification of the individual. So I heard the later end of the question. I believe that jurisdictional challenges or jurisdictional realities must be borne in mind in determining scale of charges. So like I said earlier, this is a process that we must think through very deliberately. We must think through very carefully. So I would be grateful if we could, at the SPI Ajibade ABL 2020, aggregate all of these suggestions so that we can, in the process, I mean, nobody's a repository of all knowledge or all ideas. We can, if we can get all of this together, but just be assured that in the designing process that we are undergoing at the moment, we are definitely trying to take into consideration the realities of location. Indeed, like I said to you just now, not only do we want us to bear in mind the issue of remuneration for lawyers and law firms, we are also dealing with the issue of, not only are we bearing in mind the issue of earning for the lawyer and law firms, we are bearing in mind the issue of remuneration for the lawyers who work for and with them. And that is also critical. So the lawyers who work for and with them must also be, the committee that we have put in place is taking those issues in tandem. So, and also in determining what the lawyers earn, reality of location, socioeconomic realities must also be borne in mind. What is a living wage in Lagos is not necessarily the living wage in Jos, where I was yesterday. So yeah, these are very welcome suggestions. So Shola, did you hear all of that?
Come back for the final thoughts of our panelists. Thank you. I believe the announcement of the winner of the essay competition will be done by Mrs. Bukola Iji. So after announcement of the winner of the essay competition, we'll come back for closing remarks from our panelists. Please, if you have any more questions, please put them in the chat box. We'll make sure that we send it across to our speakers and get them answered. We'll keep the conversation going. Time now for the awards.
you, everyone, for joining us today. Uh, we are particularly thankful to all the participants for taking the essay competition very seriously. We received about 60 submissions. About 4 were disqualified because they did not meet the criteria. And we also thank our judges who took time out to ensure that the Mr. Chukwuka Ikwazon, Chinua Azuzu, and Mr. Abdulatif Olashubomi Abdul. We have 5 notable entries because we found it to be particularly interesting and they address the issues in a very, very interesting way. In no order of importance, the 5 notable entries are from Hassan Sherif, Gabriel Temitope Omoniyi, Muhammad Nasser Ibrahim, Oluwakemi Stephen Adeyemi, and Olabisi Victoria Ojo. Thank you very much. And the winner is Mohammed Nasser Ibrahim. Yes, so the prize, the winner stands to win a full sponsorship for 1 certificate earning course with any of the Chartered Institute of Arbitrators, the Institute of Chartered Secretaries and Administrators, or the Chartered Institute of Taxation. Thank you very much once again. Thank you very much once again for participating. And as Dr. Ajibade said at the beginning of the program, all the recommendations and the proposals in all the submissions will be considered when we are putting together business luncheon. Thank you very much.
Can we take final comments now from our speakers? Great. So I will come back to the representative of the Attorney General. Is he still online? Do we still have the representative of the AGA for online? No. Okay. And I know Mr. President has also dropped off. He says he has another meeting to attend to. Eme, can we have your final comments?
Okay, Shola. So I just, first of all, want to really just thank SP Ajibola for this opportunity of engaging with the Commission and moving the legal practice forward. I would just like to say, in addition to all that I have said, that engagement and consultation far and wide is essential to fixing an appropriate scale of fees for legal services. And the Commission's doors are open to this engagement. So just like to encourage that and continually wish the profession speed and progress in all that we do. Thank you very much for this opportunity. God bless you.
President now.
Yeah, Shola, I'm sorry. I'm back.
Just go around the room
Yeah,
first.
Shola, I'm sorry. I'm back.
Go around the room. Please let's have your final comments.
Okay, thank you, Shola. I dropped off for a second. Just my final thoughts would simply be firstly to thank Dr. Ajibade and the firm of SP Ajibade for bringing to the fore this very, Shola, can you hear me?
Hear you.
Okay. I just wanted to thank Dr. Ajibade and the law firm of SP Ajibade for bringing to the fore, using the platform of the SP Ajibade ABL to bring to the fore this very, very crucial and very, very indeed existential issue. And I cannot even begin to overemphasize the importance of this issue. And as we all have heard, there's no silver bullet with which we can actually just nail this one down. So it is something that it's going to be a really concerted effort that is necessary. And all of us, we will need to sit around the table to come up with something that will not only be fit for purpose, but will endure. As Tola Onoyemi mentioned, if you try and come up with something that is too tight, you might find yourself needing to review and come back to it too often. And that's not what legislation is about. So, Shola, you have been trying to get commitment from around the table that work is being done on this or some positive action is being taken. Let me give you the commitment from the MBA that for us, you're preaching to the converted. For us, it is actually, it's an important matter. It's so important that nothing else trumps it. We must be able to earn living wage. We must be able to earn top dollar for that which we do as professionals. So it's very important to us. So you can be sure that not only are we taking this as an important matter, but we're going to galvanize all stakeholders. We're going to galvanize all stakeholders to ensure that in very short order, we will be able to get some kind of bearing on this issue and come up with a scale of charges that would endure for all time, or at least for the short term. Having said that, I must thank you, Shola, also, and the organizers again. So have a good one.
Okay. Final.
Okay, thank you, Shola. On a final note, I'd like to thank the firm of SP Ajibade and Co. What they've brought out today is an integral part of our self-regulation. They picked the item of professional fees. But I know that key to effective self-regulation is the responsibility and obligation on our part to ensure that the standards are met and that we remediate and discipline colleagues who are unethical or immoral and incompetent in the practice we pursue. So on this part, I think the legal profession must continue to self-regulate with even greater intensity and, very thought out and well-planned ways, not just around these fees, but about other things we do in a rigorous manner so that we don't lose the privilege that society gives to us. Because if we do, we'll be losers and it'll be very unfortunate. But I know, having heard the president and other speakers today, our minds are clear on what we want to do, and I think there will be positive action. So all I want to appeal to us is that just realize that neither economic incentives or technology or anything we do will save our profession more than our personal commitment to defend this profession that we have chosen to pursue. On that note, I'd like to say thank you once more, Shola, and your team, and have a good day.
Very much. I almost didn't hear you properly. I'm going to go to Mrs. Etim now.
All right. Hello, can you hear me, please? Hello? Can you hear me?
We can hear you.
Hear you.
Okay, okay. I'd like to really thank you, Shola, and your team for this very great session. This has been a very topical issue. And I am aware that Dr. Ajibade SN himself set the tone for this discussion years ago during a NEC meeting in Uyo in Akwa Ibom State, where I am. And it's really gratifying to note that he has sustained the tempo on this all-important discussion. As a parting shot, I would like to say that in line with what we've had the NBA president said and the representative of the Honorable Attorney General of the Federation, that in no distant time, we would see a kind of change in the law to reflect current realities so that lawyers are not so terribly impoverished as it is in the current, under the current law. I'd also like to see a situation where the new law would give a kind of flexibility, as Tola had mentioned, to lawyers, a room to play with in terms of negotiations and agreements with clients. On that note, I want to really thank you all and to say that it's been a beautiful time. The discussions have been very enriching. Thank you very much and have a lovely day.
Much, Ma. Thank you for your time and thank you for your comments too.
Thank you.
I'm going to save you for last.
It's okay.
So, Tola, for your final comment.
Thank you very much. I think just a number of things to say. First is definitely massive appreciation to Mr. Ajibade and the firm SP Ajibade for putting this together. This definitely is a very important conversation. And I think what I found most impressive about this conversation is that every player in the room is here. The Attorney General, the NBA, clients, practitioners, everyone is in the room to have a conversation. And I think, and I hope that we can take this conversation forward to actually deliver on improvement for the bar. The second thing to say is that while it's great to talk about fees, I think we should also start to have conversations about increasing the reach of legal services in the country. Like I said at the beginning when I was talking, the last poll says that over 95% of Nigerians don't have access to legal services. That's a conversation we should be having, right? About how to start to think creatively about how legal services can reach everybody and how we can increase the market size so that there is more to go around. The truth is, there is a lot of needs for legal services that already exist. And the question is, how do we rethink and redesign that to match our economy? I think too many times we've copied what has worked in larger, more deepened legal systems. But the question should be asking ourselves is, how can we have conversations about what works the best for our system? That's one. And how can we reach the underserved? How can we be distinctive about broadening access to legal services? The second option to say that stretches from that is that as we think about the whole issue of legal scale of charges, I think it's important to also include very clearly an exception for legal aid, right? So over the last few months, I've had to provide legal aid. I've had to coordinate about 700 lawyers to provide legal aid during the NSAS protest. And one of the things that we saw very importantly was that people are caught up in the detention system simply because they can't get legal support. So I think one of the things that we should start to talk about is also exceptions for that. I know the Ghanaian system has an exception that says that for poverty of the client or for legal aid purposes, you can actually waive the fees. So I think it's important to also contemplate that as we talk about our legal, about our scale of charges, to contemplate for that. The third thing to say is, I think we should be very careful that in designing that we do not come up with simplistic solutions that cause more problems in our bid to solve the scale of charges issue. So when I moved back to the country, one of the things I helped set up was the ease of doing business framework for the country. And I helped lead that for the first 2 years. And one of the things we saw was the use of things that people were trying to use to solve problems, and was actually creating bigger problems in the same stead. So for instance, someone made a suggestion about creating a new seal for land cases. The problem is you're just going to create more bureaucracy, create more problems. And the risk is this. The risk is that people would actually just not register their property, which is already what we're seeing happen in a lot of places like Lagos and Abuja, where because of the regulatory requirements, people are just not registering their property. They're just informally transferring property from one person to another person. So we have to be careful that in trying to solve for scale of charges, we don't create more bureaucracy in the system. We don't create more arduous requirements that would ensure that people do not actually follow what we're trying to solve for. The last thing I would say more generally is that, and like I said before, in the end, we should ask ourselves, what are we trying to cure for? How can we create a system that lines on people's incentives and encourages them to come into the system to follow it, that allows them the flexibility to opt out of it if they do not think it works for them, and allows them a flexibility of a bandwidth to pick what works for their geographical locations, their economic standings, and for their different experience and peculiarities. In the end, it's not going to be a simplistic work. I think it's important to have that. It's not going to be one conversation, but I think it's important to put all those things in context as we start to think about what a scale for charges would look like for the legal profession. Thank you so much for this conversation, and I look forward to what the future would look like. Yeah.
So much, Tola. Thank you for your contribution. Bumi, final thoughts.
Yeah, I promise I'm going to make it very short.
Great.
The other speakers have said a lot in their closing. What I know is from a human capital development, look at the root cause. From the root cause, then you find the solution. I believe that in the problem, we are gradually finding a solution. So this is a good step in the right direction, right? And from the questions, we found the answers. So it's for us to get back to work. We have the stakeholders around that have listened to all our submissions, and I believe that they will get to work and implement these things. Thank you very much, Dr. Ajibade, sorry, SAN. Thank you for this, making this possible, and I must say that this has been a very interesting and enriching session for me as well. Thank you.
Thank you, Bumi. Dr. Ajibade, vote of thanks.
Yes. Good afternoon, distinguished ladies and gentlemen, those of you that are still with us. This has been a wonderful session, bar technological hitches. We're so grateful to all of you, to our panelists, the Honorable Attorney General, as ably represented, the President of the Nigerian Bar Association, the Chairman of the NBA Eket branch, Mr. Raymond Ingberkwe, my good friend at First Bank, Mr. Erukera, the Executive Vice Chairman of the Competition Commission, and Reginald Aziza, ably represented by my good friend and brother Tola Onoyemi. Thank you all so very much for honoring our invitation. As Tola said, I think we achieved our objective in getting all the relevant stakeholders into the room. And in starting this conversation going, we knew that we weren't going to arrive at a solution today, but I think it's important that we start the conversation with a view to arriving at a solution. And I must thank our moderator, Mrs. Shola Shoyele, judiciary correspondent of Channel Television. She's handled this masterfully. And I must, of course, thank all of you who have taken time. It's been a longish session. I guess it's not a typical webinar. It's supposed to be a business luncheon, just that it didn't come with the food. We thank you for your patience. We thank you for staying with us. We pray that by this time next year, when we're having the 14th edition, we will have no cause to have it virtually, and that we'll be able to revert to a business luncheon that actually serves lunch. Thank you all very much.
Thank you very much, Dr. Ajibade.
I apologize. I did not mention Mrs. Omeke. I'm sorry. That was, and you see, that's what they say about familiarity breeding contempt. I thanked everybody who wasn't here, but then I forgot to thank the panelist who was here, Mrs. Bumi Omeke of JGC Partners. Thank you so very much for joining us. Thank you.
Thank you, Dr. Ajibade. I believe that we've had over 200 people online joining in this conversation. And Dr. Ajibade has said it all. We thank you all for staying on and for joining in. I apologize to those that I couldn't take their questions. Please keep them coming. We will send it out to the relevant authorities, and we'll keep the conversation on the front burner. Like Dr. Ajibade said, it's a good thing that we've started this. We didn't think that we would get solutions today, but at least the conversation is out there now, and we're all going to keep it going. And with that, we come to the end of this webinar. Thank you, everyone. Thank you to all our panelists. And the session is now closed.
Thank you very much.